In addition to, no doubt, an extremely busy career, he's also involved in tutoring as an associate tutor of the Hewarding Law School, and has indeed been a major contributor to many conferences, both local, regional, and overseas, and presented numerous papers. And once again, if I were to go through all of those, I think this would cut significantly into your lunch break. So in the interest of time, perhaps I wouldn't do that. I would, however, end by saying that amongst his other interests, reading, football, and poetry. So I'm not sure which of those he might be looking to share with us this morning, but I invite him to the podium, Mr. Roger Gaspard.
Good day, one and all. I would like to extend a special welcome to the Chief Justice of Rwanda, Justice Adrian Saunders from the Caribbean Court of Justice, other judges, members of the magistracy, other distinguished guests, delegates, colleagues, and friends. It is my privilege and indeed a signal honor to have been invited by the Mediation Board of Trinidad and Tobago to participate in its 5th annual symposium. I am also very humbled to have been given the opportunity to share the company of so many knowledgeable, well-intentioned, and creative persons in the justice system in general and in the field of mediation in particular. Undoubtedly, several of these persons are better equipped than I am to speak on this topic. Nonetheless, my office, being a critical player in the criminal justice system, I welcome the chance to make my small contribution. Within recent times, Trinidad and Tobago has been blighted by galloping crime and by a murder rate that almost defies belief, especially bearing in mind what is a really or a relatively small population. Those amongst us with a sociological or criminological bent might hasten to point accusing fingers in the direction of the family and its breakdown as the core sociological institution, the failure of our religious leaders, ruthless individualism, or the perceived or sometimes demonstrated incompetence of law enforcement, the prosecutorial authorities, and the justice system in particular. Almost invariably, the instinctive reaction to increase levels of crime is a bellowing for more law and for the heavier infliction of punishment on criminal wrongdoers. It is in this context our criminal justice system is usually nudged in the traditional way towards the embracing of retribution and punishment as the touchstones of justice. This is not surprising given the legacy of our colonial past and our inheriting of a system of justice which now appears to be out of step with our social and conventional realities. In Trinidad and Tobago today, the current criminal justice system is adversarial in its very nature. Essentially, this system is primarily concerned with which laws were broken, who broke those laws, and the prosecution of the suspected offenders. Where does this leave the victim or victims of crime? Especially bearing in mind that the adversarial system does not allow victims of crime to walk away with anything more than a nebulous feeling that the offenders have been punished. A question I wish to pose rhetorically is how has this system impacted positively on the housing situation in the prisons? How has this traditional system impacted positively on our current rates of recidivism? How has this current system, this traditional system, impacted upon the perception and feeling of marginalization within and alienation from the justice system as expressed and experienced by many victims of crime, and indeed by the wider community? Permit me to pose a further question. What exactly is the pervasive feeling among the citizenry about the criminal justice system in light of the sluggish disposition of cases and a sometimes mysterious shortage of funds for injection into that system? Ladies and gentlemen, how does the current system positively impact upon incarcerated persons who are destined to return to society, whether society likes it or not? How, dear friends, does the current system cater for the reintegration into society of persons released from prison? Does the current system make for the reintegration of these persons into society as productive, non-offending members? Of course, the germination of certain seeds planted during our colonial past and our post-colonial present reality oftentimes lead us to adopt a we versus them approach, which must surely be reappraised. After all, when we disparagingly criticize and alienate the so-called criminal element and those returning to society having been incarcerated for their criminal past, we usually misremember that these persons did not come from Mars. They would have come from amongst us, our homes, our schools, our religious houses. They are ours. It is against this backdrop that I propose to tackle the topic today, innovations in the justice system, with the accent on mediation. It can hardly be gainsaid that there is now a burning need for us as a society to explore and to search for creative solutions to our criminal malaise. Happily, and owing to the perspicacity of the judiciary, we are well on the way along the road of diversion from the traditionally established retributive options. Thus, the prevailing winds in this regard have deposited at the feet of our justice system the advent of drug treatment courts, a renewed focus on plea bargaining, and a hospitable climate for the flourishing of ideas rooted in several restorative justice models. May I invite you to consider whether mediation can play a useful role in the augmenting or amelioration of our criminal justice system. In certain circles, the viability of mediation in the criminal justice system has been difficult to sell. Some persons inelastically contend that mediation ought to be confined to civil matters and indeed has no place in the criminal justice system. In point of fact, some stakeholders are of the view that mediation initiatives send a sorry signal of surrender to persons committing crimes. Others argue that mediation initiatives as they relate to criminal wrongdoing represent yet another abandonment of the victims of crime and the wider community. I beg to differ, especially since in those countries which currently utilize mediation, mediation processes are never utilized without the consent of the victims. Such countries include the United States of America, Norway, Finland, Canada, and Australia. Usually, If no such consent is forthcoming, the offender must participate in the traditional criminal justice system. The main type of mediation used is the victim-offender mediation process, sometimes used conjointly with another variant of dispute resolution, namely restorative justice counseling with both adults and youths. Victim-offender mediation is primarily focused on bringing together victims and offenders in a safe and structured setting where victims are able to question their offenders or their offender and discuss how they were affected by the crime. The goal is to hold the offender accountable for his actions. Victim-offender mediation engages both parties personally in the negotiation of an acceptable plan that addresses both their needs and their obligations. Victim-offender mediation typically follows a 4-step process, which differs from the typical mediation method. In a typical mediation setting, two parties come together to resolve a dispute, and the parties work to reach a settlement based on the assumption that each party contributed to the conflict. However, victim-offender mediation is a distinct form of mediation which begins with an innocent victim and his offender who has already admitted to committing the crime. In such a setting, communication is the main objective, and the goal of determining proper retribution is not an issue. The parties are therefore less interested in negotiating a settlement and more concerned with confronting and communicating with each other. After a thorough screening process, victim-offender mediation brings together victims and their offenders who voluntarily agree to engage in face-to-face dialogue with the assistance of a trained mediator. In these meetings, victims are able to ask questions such as, "Why did you do this to me?" in order to ease their minds and feel secure and whole again. Offenders learn the consequences of their actions, understand the enduring effects of their criminal acts, and may apologize and or gain forgiveness. Through this dialogue, victims are able to understand who their offenders are and what may have caused them to commit the crimes. Another fundamental purpose of victim-offender mediation is to afford the victim an opportunity to confront his or her offender in order to better understand the situation and to facilitate the healing process. Therefore, in order to be a candidate for victim-offender mediation, the offender must have admitted to committing the offense, and he must voluntarily agree to participate in the mediation. Additionally, this dual prerequisite ensures that the offender will not be adversely affected by opting not to participate in the program. Without this voluntary requirement, the entire foundation of victim-offender mediation would be compromised. This type of mediation can be used in a variety of cases, depending on the severity of the crime. Mediation should not be used as an alternative necessarily to the traditional system of criminal prosecution, but rather as a supplement. For example, although mediation involving less serious crimes may be appropriately used as an alternative to the prosecutorial system, mediations involving more violent crimes should be held in conjunction with the prosecutorial system, especially in a society where the idea of mediation as an option in the criminal justice system is still a rather novel one. Obviously, not all criminal matters may be appropriate for mediation. Mediation involving individuals with pre-existing relationships, such as family members, business associates, and neighbors is more likely to have a successful outcome. The question may also arise, how might the mediation process be triggered and when? There are several clearly defined stages where mediation is utilized in the criminal justice system. Mediation may be recommended in certain cases before the court delivers its sentence, but has already partly adjudicated in the matter. Pre-sentencing mediation, for instance, is mostly used in Australia when dealing with adult offenders. In Queensland, their program allows police officers to divert youth offenders away from the traditional criminal justice system and onto the pathway of the mediation process. In Maryland, United States of America, prosecutors may refer cases on their docket to mediation. Criminal defense